What's up, viewers, subscribers, and agents alike? It's your boy, Luciferian Prince, coming at y'all once again. Welcome. Thank y'all for being here, and we going in. As time is, it is what it is. Let's do our thing. First off, if you're watching this video around children, please remove them from your immediate vicinity, as my videos are not for children. Okay? They skedaddle to Seattle. Now, also to mention, if you are seeking any type of legal advice, this video is not that. All right? This does not constitute legal advice. The sole purpose of this information is educational and general purposes only. If indeed you need help, seek you an attorney. I'm not an attorney. As I say in my videos, I'm a man that just loves to read. Simple as that. Now let's get to it. Now that time is of the essence, right? So the title of this video is Form 56F. Now, it's not the same as Form 56. It's 56-F. And it's notice concerning fiduciary relationship of financial institution. Now, I know I said previously before in the video in regards to the claim of depository insurance and so forth and so on. So if you're following me, this still goes along those same guidelines, okay? Now, what you're basically doing with this form is that you are basically telling them, quote, the financial institution, that, you know, you're letting the IRS know your relationship in regards to them. And what you're doing in regards to this is basically, again, it's perfecting your power of attorney, in fact, in regards to this financial institution, okay? So now it says the name of the person to whom you are acting as shown on the tax return. You should already see that. That's common sense. City and state. So it says, for particularly what type of financial institution? Is it a bank or thrift? Well, we already know we're talking in regards to banking. Fiduciary's name, the contact person, address, that would basically be corporate office for your financial institution. Or if you can't find the corporate office information, pretty much where your branch is located. Either or, still going to get to the right entity, still going to get to the right person. Might take a little longer, but it's still going to get there. Now it says all the information in regards to the person for whom you are acting, that would generally be the beneficiary, which is yourself. City, state, zip, all that good stuff, and authority, which is authority, evidence of fiduciary authority. So you can just read it: appointment conservator, appointment receiver, replacement of conservator, order of insolvency, or other. Evidence of creation of fiduciary relationship, which I already said previously in the video in regards to the Form 8822 and the claim of depository insurance. All this goes together as a package along with your power of attorney. In fact, if you don't have one, I suggest you make one, which is an irrevocable power of attorney. In fact, not a durable, not a limited, none of that. No additional party to it. It's just irrevocable, which means you are the sole power of attorney, in fact, in regards to your commercial affairs. Tax notices, which is really relatively not important. But then you also want to revoke or termination of notice. So now you have the revocation, which is part 4. Evidence of termination or revocation of fiduciary authority. A, certified copy of court order revoking fiduciary order attached. Copy of certificate of dissolution or termination of a business entity attached, or other, which is the documentation I just said that you put all together and you attach to Form 56-F along with that documentation. Now you sign, and basically you're just letting the IRS know your relationship with the fiduciary relationship with the financial institution, which is the bank. Why is it important, people? Because these are the forms, these are the documentations that we otherwise have not utilized in order to establish our relationship concerning the fiduciary relationship of a financial institution. Now, we so loosely throw that term around, right? And what we don't understand is we have to understand this legally. So for people who don't know what fiduciary means, let me read it for you. A fiduciary is someone who manages money or property for someone else. Do you understand? When you are named a fiduciary, accept the role, you must, by law, manage the person's money and property for their benefit, not yours. So in other words, when we're talking about a person in law, we're talking about you managing the finances of the principal person, which is the trust, okay? Which is the straw man. It is your job to act as you. Fiduciary, involving trust, especially with regard to the relationship with a trustee and a beneficiary, okay? So now you understand that the trust is the corporate soul, and you, the natural person, are basically the fiduciary. It is your responsibility to make sure that you put yourself in the power of attorney in fact capacity to handle business. Are you competent enough to handle that is the question you must ask yourself before embarking upon any of these endeavors. Are you mentally capable of handling these fiduciary responsibilities? In the monetary fractional reserve banking system, what we call i.e. commerce today, is just everyone knows how to spend and receive money. But do people really know how to stand in a capacity as a fiduciary, which means that basically we're not spending anything. We're going to do what we do best. Use the savings account for just what it is, to ledger savings as far as what is considered a deposit. What we should do as the responsible fiduciary is to put obligations that otherwise would jeopardize that trust and make that trust liable. As a fiduciary, you are supposed to limit the liability to the trust, and you're supposed to discharge it in your natural capacity by substituting who the fiduciary is. Now, when you substitute the fiduciary relationship on any level with the FDIC and your financial institution and the IRS, you are now in the principal position as a secured party. In other words, any liability does not fall to you, nor does the trust become liable. So the trust is basically indemnified from any liability. But that's what you're supposed to be doing in the first place. If you're not doing this, trust me, financial institutions will not inform you of your lack of fiduciary responsibility. They're going to tell you you owe something, and that's on you. That's your responsibility, but you're supposed to also establish a relationship between you, the natural person, on behalf of the trust, and make sure that the fiduciary dissolves all liability in regards to that trust, and you must enforce that through power of attorney in fact, and that's in less than 8 minutes. I tell people on my channel for very significant reasons, I don't like my videos drawn long and bore you with certain species and everything to try to intrigue you. I want you to get this information compactly, quickly, and understandably as possible. Other than that, everything else is pretty much on yourself. Now I'm going to pause with the uploads for today. I had 2 more, but why ruin the fun? As long as I can keep you intrigued as far as knowledge is concerned, and you applying these things, so I'm going to allow my audience a chance to catch up, then I'm going to pause on the uploads for today. I thank y'all for tuning in, and please understand that these videos are for your educational edification. Now, if people want to consult me and basically, have a one-on-one for things that I cannot say, well, for strict reasons, because it's not legal. When it's a consultation, it's a different story. But that's a different story. Contact me on the private side. Serious inquiries only. And if you're new to my channel, yes, my consultations do cost. I don't put fees out there as online because, again, that has never been my style. It's personal. It's a one-on-one situation, per case basis, per situation. So that's what I do in my personal life. As I always tell all my viewers, it's never the knowledge. It's my time you pay for. So whatever I place in regards to your response, if you fit the bill, we can do it. You can't, it is what it is. I understand. Everybody's not made of fiat. We get that. But it is all right. But my time is very valuable, worth more than any so-called paper dollar that can be given to me in regards to my particular energy. So I'm just going to put that there. But in furtherance of the education for people who are following me, please continue. Hit the subscribe button. Hit the notifications. Again, I'm not responsible if you get notifications or not. That is not me. I just make the content for the channel and I put it out there and boom, it is what it is. Whatever happens with the algorithm or other unseen entities, that has nothing to do with me. But make sure you do check back, because if you watch my video once, you watch my video twice, and you continuously watch, then maybe I will pop up on your feed. I can suggest that. Other than that, if you wish to donate for the channel, my information is in the video description, also in the comment section below. All my information per consultation, per Google number, if you wish to contact me via that, is perfectly fine with me. But people, remember, knowledge is power, but it's only powerful if you execute it. Other than that, it's just information. So thank y'all for tuning into these uploads. Y'all stay tuned. Got more tidbits of information coming for y'all, so y'all can get ready to do y'all thing and take this into consideration. Knowledge is power, but it's only powerful when you execute it. Other than that, peace, light, love. Y'all stay tuned for the next upload. Agents, fuck you. Y'all take care. I'm out.